Refusing a breathalyzer is a serious DUI criminal charge, but there are 5 powerful legal defenses that can help you fight it. I'm Dan Joffe, DUI lawyer at NextLaw. In this video, I'm going to break down 5 defenses that could potentially save you from a DUI refusal conviction. First, I'll show you how an invalid police demand could completely change your case. Second, you'll learn about charter violations that could get your case thrown out. Third, I'll reveal what counts as reasonable excuse for refusing. Fourth, we'll dive into technical problems with the device that could help your defense. And fifth, I'll explain how the timing of your last drink could actually matter. By the end of this video, you'll understand exactly what defenses are available if you're charged with refusing a breathalyzer test. Part 1, the invalid demand defense. Now, let me tell you something most people don't realize. The police just can't casually ask you to take a breathalyzer test. They need to make what's called a clear and unequivocal demand. Think about it this way. If an officer asks you, would you like to take a breath test? That's actually very different from saying, I demand you provide a breath sample. This distinction may seem small, but in court it can make all the difference. Cases have been thrown out simply because the police officer phrased it as a question instead of a demand. Remember, the law requires clarity. There can't be any ambiguity about whether you're being asked or told. Part 2, charter violation defenses. Now, this is where things get really interesting. Your charter rights are like a shield, and if the police breach these rights, it could be your way to winning your DUI case. Let me break this down for you. First, you have the right to speak to a lawyer. And here's something crucial. While you don't have this right for roadside testing, you absolutely have it at the police station. If they deny you this right or rush you through it, that's a serious charter violation. But it doesn't just stop there. Was your detention lawful? Did they have reasonable grounds to demand a breath sample? Was there an unreasonable delay? Each of these could be a charter violation that could help you with your case. Part 3, the reasonable excuse defense. This is probably the most misunderstood defense of all. Many people think they need to prove their excuse beyond a reasonable doubt. That's not true. You only need to raise what we call an air of reality. Let me give you some examples. Medical conditions like asthma, COPD, or even broken ribs can make it physically impossible to provide a proper sample. Even severe anxiety or being elderly could qualify. The key here is that once you raise a reasonable excuse, it becomes the Crown's job to disprove it beyond a reasonable doubt. Part 4, problems with the device. This defense is all about the technical side of things, and you'd be surprised how often it works. Think about it. These devices aren't perfect. They need proper maintenance, correct calibration, and proper setup. If the device wasn't calibrated correctly, had a faulty mouthpiece, or wasn't set up properly, any of these issues could be enough to challenge your refusal charge. Part 5, the mouth alcohol defense. Here's something that might surprise you. If you had a drink within 15 minutes of the test, it could significantly affect the results. This is what we call the mouth alcohol defense. In fact, if an officer knows you just left the bar, they're supposed to wait before demanding a breath sample. Many don't know this, but this waiting period is crucial for accurate results. Now that you understand these 5 defenses, you can see why breathalyzer refusal cases are far more nuanced than most people realize. But remember, these defenses require proper legal expertise to execute effectively. If you're facing a breathalyzer refusal charge, schedule a free confidential phone call with me. The link to book the meeting is in the description of this video.